Everyone, please be seated. We are here this morning for the submission of 3 cases. The first case is Estate of Griffith versus others, and it looks like the parties are ready. And it's my understanding that Mr. Gourley and Mr. Wagner will share time, and that Mr. Wagner is going to go first. Okay, we'll let you guys decide how to divvy up the time. And we will begin with Mr. Novak.
May it please the court. The main issue before the court is whether this court intends to change the standard to prove gross negligence. The standard for gross negligence was adopted by this court in Thompson v. Spokane and requires substantial evidence of actual knowledge of the peril to be apprehended, actual knowledge that injury is probable as a result of that peril, and a conscious failure to avoid that peril. The district court and the Court of Appeals relaxed that standard. They relied on a should-have-known negligence standard plus additional circumstances. They applied that same should-have-known standard to both an on-site supervisor and a corporate-level manager. The same theory, the same evidence they relied on. Both defendants had knowledge that there had been no injuries under the same circumstances on the same equipment for almost 20 years. And they had no knowledge of the peril which everybody speculates was the cause of this unwitnessed accident. And under the circumstances, unless this court is going to overrule the precedent of Thomas v. Spokane, judgment notwithstanding is required. So what was the specific peril that changed routine work to non-routine work involving a hazard? What was that specific peril? Who knew about it? When was it discovered? And then most importantly, what did they do when they learned of that specific peril? And in this case, those are the questions that should have been asked by the district court. The district court should have determined what that specific peril was and the answers to those questions. Instead, the court was able to focus on, well, how could this have been avoided? How could this accident have been avoided? That's what the district court did.
Peril was the missing pins and the gate being down.
Is an open gate, exactly. It's the railings on top of the catwalk. It's a portable piece of machinery, and there's a gate that is able to go down. No one knows how the gate was opened, who opened it, or when this all happened. And that includes both defendants. There's no evidence that either defendant had actual knowledge of an open gate, which would likely result in serious injury or death. In fact, Brea's own expert, Randy Van Winkle, testified he thought it was most likely that Michael removed the pin. He testified that being on this catwalk could be dangerous, but it becomes an imminent danger when that pin is removed. That was the testimony from Brea's expert. Brian's expert testified as long as the gate's up and the pin's in place, it meets MSHA standards. Not a single employee in this case, not a single one, testified the configuration of this bin was considered hazardous before this happened. After this happened, they went together and they tried to think of how could we prevent this from ever happening again, and came up with a laundry list of things to think about.
1996, what was the prior injury, or is that in the record?
Injury is in the record, but what's in the record is it was a different configuration of the bin. They didn't have any railings, and people would take samples off the top reaching over from the catwalk. That's why they put up the railings, and that was the change. But cases involved...
Imminent danger test fit into these 3 elements. Where does that fit in your view?
When there's an open gate that somebody knows about, there's always a danger involved anytime you're doing work as a surface miner, whether you're driving the trucks, whether you're operating equipment. That's routine work. What made it non-routine and what made it imminent would be an open gate.
The elements of the gross negligence claim, which element is that relevant to determining?
I think it's both 2 and 3. I think to get 2 and 3 together. And if you look at the cases where gross negligence has been established, for Swanson, for example, there was a defective safety suit. It was known by the supervisor that it was defective. Supervisor said, go to work anyway. What if the supervisor didn't know about the defect in the suit? Would that be gross negligence without actual knowledge? In Larson,
Yeah, well, we're talking about the cases. What about the Alden case? That seems to have some constructive knowledge language in there. I'm just reading from Alden. The plaintiff must show that the defendant knew or should have known that his conduct placed the plaintiff in a zone of imminent danger.
language is troubling. If you look at Alden, though, Your Honor, it involves whether there's summary judgment or not. The defendant denied ever instructing the person to do that work, denied having knowledge of the specific condition. And I think it was loose language and a very short opinion. If you look at this court's decision in Walker after Alden, it makes it clear that we have said that wanton conduct involves, among other things, a realization of imminent danger. Of course, such a realization is not possible without actual awareness of a certain peril or hazard and an almost intentional disregard thereof. And I think it's that later language that makes Alden clear that those are different circumstances. And I think Alden was at that summary judgment level.
Conduct fit in, the individual defendant's conduct fit in. In Alden, what was the specific conduct?
The supervisor, the person that was injured was working in a man lift in the back of a pickup truck. And the conditions were that it was windy the second day. And there was a factual issue as to whether the supervisor knew they were going to do it a second day, knew it was windy and things like that. I hope that answers your question.
But the supervisor, at least there had been a complaint about it being windy and told them to go ahead and use the man lift in the back of the truck. Is that, so is that where the specific knowledge versus the constructive knowledge comes in? Does it focus on the defendant's conduct itself?
On the defendant's conduct in the totality of those circumstances.
That here that's alleged against the two defendants.
General condition. And I can't answer that question because the defendants knew that the work was being done in the same manner and the same way as it had always been done.
Evidence about so the hopper had been put together at this location just the day before, is that right? So what's the evidence about what the supervisor's duties were with respect to inspecting it? Was there something special about a first inspection after the hopper was put together?
For Wendling employees, this hopper would be moved 7 to 8 times a year. And so it had been done that over a course of 20 years. Drew Bixler testified he put it together maybe 50 times. There had never been a problem, never been a problem. And the general inspection, frankly, is what there is. There's not an inspection of each piece, everything that's done. And we're not aware of anyone that's said that one is required. And the whole idea of an inspection is there wasn't one that was done in terms of a detailed inspection. There was argument that, well, he made a very general inspection. He didn't inspect every piece of equipment on that site that all of the miners were going to use. It's just not that one piece. This would be a different case if Mr. Galloway had gone up on the catwalk, was able to find a pin was missing if that's what it was. We don't even know. And then didn't do anything about it and still instructed somebody to go up there and work. That would be a different case.
Requirement incentivize sloppy safety inspections, or where they're better off not knowing about a specific hazard, that if they had looked, they might have seen it?
I think it's one of those questions, it's a loaded question, Your Honor, in the sense that we can always say that. At whatever level do you say, we didn't do something, we didn't do something? And so the answer is yes, at some point. I think you have to say, Did they consciously fail to do something, but still with realization that there's that imminent zone of danger? Here we've got a supervisor who did the exact same work in the same manner, hundreds of times, and didn't feel it was unsafe.
Court of Appeals failed to address that point.
Refused to give a requested instruction on that issue to the jury, that they could consider that as evidence of knowledge.
Circumstances where the failure to inspect in and of itself is gross negligence?
I would think it would depend a lot on the circumstances. Are we dealing with hazardous materials? Are we dealing with selective things? I mean, if we look at the, which case is it when they were dealing with dynamite? To me, that would have been a case to bring that issue up. You're dealing with dynamite, or is that a case where you should do an inspection to know the conditions?
No harm from the failure to inspect. Maybe that could be gross negligence in certain circumstances.
Too, on the probability of harm in the sense that if you'd had somebody fall in recently, if there'd been recent injuries of this kind, would that change the calculus?
I think if that's true too. And I think if there had been a history of workers saying this pin falls out, or there's something of that nature, that might trigger a more detailed duty to inspect. But here we've got something that's been done the same way at this location and 7 or 8 other locations in the same manner without incident. And keep in mind, the same evidence is used for an off-site supervisor miles away in management as the on-site supervisor. And we're applying the same standard to both defendants in this case.
I had a question about that. Prior to the jury verdict coming back, did you ever try and argue separately Mr. Kulper's situation and say, regardless of what you do with Mr. Galloway, Mr. Kulper's entitled to a directed verdict because, his circumstances are different. He wasn't even near the scene. He's a, overseer of safety who works miles and miles away. Did you ever try and make that argument?
Directed verdict motion. It's also why Mr. Minot was dismissed as the president of the company, because that was made separately for each defendant. The directed verdict was on all grounds for all 3, but it was made for each one. And that argument was made.
Instructions, the marshalling instruction on gross negligence, what was objectionable about that?
The court failed to define or require actual knowledge of a specific peril and used an improper standard in that definition of probable. No Iowa case has held that an insufficient training in and of itself is gross negligence. And yet that was one of the specifications of negligence. The court also refused to give requested instructions that did state correct statements of the law and were not embodied in other instructions. And this court has said that under those circumstances, the court's required to give those instructions. If you also look at the quote out of Walker and compare it to the jury instructions, for us to say that a co-employee's constructive knowledge or constructive consciousness of a hazard without any actual knowledge thereof is adequate to establish the co-employee's gross negligence would be to require safety plant managers and safety engineers to become the insurers of other employees for every potential, real or otherwise, peril within the plant. If you look,
I think we specifically said that involved, we were only addressing elements 1 and 3, where we've said you have to have actual knowledge, but in the second element, there is at least some room for constructive knowledge. Does that make Walker less relevant here?
it makes Walker less involved here at all because there's still no actual knowledge of any specific peril, which I believe is going to have to be required. And if you look at the court's instructions, Your Honor, John Culperly knowingly failed to ensure the walkway was suitable, failed to ensure adequate training. And that's the language, I think, that Walker says, no, that's not enough.
Specific does the knowledge have to be of the the peril? Does it have to be that the pin was missing or could be missing? Is it enough that it would know that it would be dangerous without that pin? How specific does the knowledge have to be?
It has to be specific in the sense that that's the word imminent danger. I mean, something can always go wrong anywhere under unforeseen circumstances. It's when we have a known circumstance that we don't take action on that should lead to gross negligence. One other matter, the Court of Appeals made a lot of findings in its decision that I don't think are supported, and I encourage this court and your clerks to use a word search for hazard, inherently dangerous, pin, and see what you find out about employee testimony. I see my time is up.
Get a chance to come back. Mr. Wagner?
May it please the court, counsel. I represent Brea Griffith individually and as the administrator of Michael's estate and also as the parent and next friend of the minor child. Michael was 30 and Brea was 29 at the time of his death on January 8, 2020, and they had a child that they were expecting in 5 months. Michael was employed by Wendling. Brea was a special ed teacher at Independence School. Their daughter is now 5.5 years old in kindergarten. There was overwhelming evidence to support the gross negligence claims of Brea and the estate and the child. In a fact-sensitive case, we presented 31 witnesses over the course of 7 days, 9 of which were the former or current employees of Wendling, and they made significant admissions in our favor. A rural Benton County jury rendered a verdict in the amount of $2.65 million approximately for my clients, primarily in regard to loss of consortium. What I want to focus on is the admissions made by the co-workers of Michael. First of all, Travis Galloway, one of the defendants, he was the plant supervisor on January 8, 2020. He acknowledges that he did not walk onto the catwalk to inspect it. He acknowledges that he should have. He did not know whether the gate was down on the morning of January 8, 2020. He acknowledges that working around the hopper was inherently dangerous. He also says that there are at least 6 different safety alternatives, had they been employed, would have saved Michael's life. I went through each one of those with him, and some of these were very simple. They were things like a 2-person notification system. If somebody was up on the catwalk, there had to be somebody on the ground to watch and make sure that that person was safe. A safety harness and lanyard would have saved Michael's life. They were required to be worn under the safety manual, but nobody enforced that manual. All of the safety measures were available at that time. They were cost efficient and they were simple to implement.
Okay, I will. I think, of course, what happened is absolutely shocking, horrific, terrible. Nobody, I don't think, on this bench would disagree to that. But everything you've just talked about leading up to it, you know, that he didn't actually walk on the catwalk, that he didn't know that the gate was down, that there were 6 safety alternatives for safety alternatives. That sounds like a lot of negligence. What did or did not happen that is grossly negligent? I always think of it as shock and awe. What will get our attention? Because most any horrific accident is going to involve some negligence. So I'll give you those. But what makes this more egregious than negligence?
The last point on Mr. Galloway I want to bring to the court's attention, and that is that he was required under M.G regulations, under their own safety regulations, to adequately inspect the system of machinery that they had hooked together to create lime or to create ag lime. And what he was supposed to do is go inspect that to make sure the pins were in place, that everything was ready to go. They had just moved it on January 7, 2020, and it was ready to start up, and they continued to complete some of the readiness on the morning of Michael's death. Mr. Galloway, pre-dawn, in the dark, did nothing more than shone his lights on the base of the hopper. He didn't get out of his truck. He acknowledges that he couldn't see whether the pins were in place or not. To me, under Section 85.20, that is the very definition of wanton neglect for the safety of another.
Strikes me as bad, as negligent as that is, and I agree there's plenty of evidence, I think we all think there's plenty of evidence of negligence, and that, you know, if Mr. Griffith were not an employee, this would be a really, really easy case to affirm the jury verdict. But don't you have to show knowledge, awareness of the danger, not merely should have known of the danger? And where's the evidence that Mr. Galloway had actual knowledge that the hazard was present?
I don't think you can not do your job and then say and be completely released from any liability because you didn't do your job at all. So that's my first response to Your Honor. You also asked about Mr. Kulper, and I want to go there for a moment. Mr.
Galloway, is there any evidence in the record about when they moved the hopper and reset it up that there was a detailed inspection like you're talking about where he would go up and check the pin? Or is there any evidence that the pin came out easily? Or is there any specific evidence related to the pin and what Mr. Galloway would have, should have done, or would have done?
Wyatt Wilson's testimony. What he said was that, first of all, he said it was a dangerous job to scrape the hopper. And Wilson also stated that he doesn't know whether he installed the hitch pins on that morning. The hitch pins may or may not have been in place on January 8, 2020, and the result would be catastrophic if they weren't.
Identified as a defendant?
Identified as a defendant, but I'm responding to your question as to whether the hitch pins were in.
Someone who had the responsibility for putting the pin in and might not have, that sounds like
Talk over you.
might be gross negligence, not putting it in. But it seems like Mr. Galloway is a step removed from that. If it wasn't his job to put it in, it was just his job to generally inspect.
But it is most certainly Mr. Galloway's job to inspect and make sure the pins were in. He was the designated, quote, competent person, end quote, to perform that. He was supposed to do it every morning. He was particularly supposed to do it when they first set it up. And this was the first morning it was running at the Garrison location, at the Garrison mine.
Applying our legal standards, how specific of the peril, or what knowledge is, how specific do we need to get with respect to Mr. Galloway's knowledge about the peril? How would you describe what the peril was in this case?
In this case, to me, is the fact that if I go to my summary page and what these folks had to say about the hopper itself, the lime surge hopper, Mr. Galloway called it inherently dangerous. Mr. Kaspar has called it a particular hazard. Mr. Wilson, we've talked about a little bit, stated that it's a dangerous job and a walkway at the rim was not suitable to prevent a miner from inadvertently falling into the surge hopper. Mr. Kulper says it's insanely dangerous if you fall into it, and it will likely result in death. To me, that is
On the I mean, just the way the whole thing is configured as opposed to the specific. So it doesn't, he doesn't have to have knowledge of this, of what it was that caused Michael's death, or caused him to fall in. It's just the fact that the whole thing was inherently dangerous.
and it seems to me that he has to do his job.
So, as I understand the standard, you have to show that the defendants not only know of a possible harm, but a probable harm, and that brings to mind the idea of what other accidents have happened. And counsel, I think, said there'd been no other similar injuries for 20 years, is my notes. Is that correct?
Testimony of Mr. McPherson, he was a former employee. He was a crushing superintendent from 2000 to 2015, and he observed another miner in 1996 fall into the hopper. A number of the people Bixler, Kaspar's crews were also there at that time. So that's when it happened.
Struggle with the notion that this kind of accident is probable if it hasn't happened since 1996.
I think that it was an accident waiting to happen if you don't inspect it like you're supposed to.
Kulper?
Yes. And I'm sorry.
I can wait.
Say this about Mr. Kulper. He didn't know whether the plant had to be inspected or at all after it was moved. He was uncertain to the extent of Michael's training. He was aware of kill switches and knew they were cost efficient but didn't employ them. I think that, again, there were people here not doing their job, and that's the gross negligence.
On site, do I have that correct? And it was his job to sort of look at paperwork kind of more generally to make sure that people had been trained?
May it please the court, counsel, I will try to go very fast. The magnitude of the danger, I think, was a good point to bring up. Very briefly, OSHA exists to keep our workers safe, occupational safety and health. Mining is one of the most dangerous professions in our entire country. It's so dangerous, in fact, that the federal government has deemed fit to make a MSHA, a mining-specific OSHA. The most dangerous part of surface mining, the evidence says, is working from heights, elevation, and the most dangerous possible job in a surface mine is working from heights over a dangerous machinery. I think it's very akin to a bomb. The evidence suggested that while this machine was running, that he had to lean over and scrape it with this long pole. And everybody agrees, if you come into contact with the interior of this machine, then that's going to result in serious injury or certain death. I want to go briefly to the actual elements. There's been some conflation, I think, by the defendants in peril versus danger, the elements 1 and 2. The actual knowledge required by the actual knowledge that is required is only under element 1. That is where actual knowledge is certainly required. But a peril is more general than an imminent danger. That's why they're two separate elements. If they weren't two separate elements, they wouldn't be bifurcated. They wouldn't be separate.
The part where you only need constructive knowledge?
Absolutely, and that's in element 2.
Where other than Alden?
Let me cite the cases for you, Your Honor. Thompson starts. An act of such unreasonable character in disregard of a risk known to or so obvious that he must have taken to have been aware of it. That's where Alden originally kind of draws, I think, this idea that constructive knowledge can get us there if it's a dangerous enough situation. Subsequently to that, obviously, Alden was decided, which said knew or should have known. Subsequent to that, Alden has been cited favorably. And once again,
Alden does seem to have maybe some loose language that maybe, kind of imports some concepts of negligence as opposed to gross negligence. And then the year after Alden was decided, and I don't normally do this kind of thing, but Alden was a panel decision. Then you have Walker, which is decided by the full Supreme Court, because back then we had those panels. And Walker doesn't even cite Alden and seems to go back to that kind of more of a pure knowledge standard as opposed to should have known.
we agree that the language used by the various courts that have construed gross negligence has not always been consistent. Makes it a little bit difficult. That said, Alden, the language, I mean, it was called loose language by the defendants. It is a holding of that case. It has not been overturned. It is the law of the land, and it has been cited favorably in Tizer v. Hollerau. That's an Iowa Court of Appeals decision. Oppendahl v. various examples of the Iowa DOT. Estate of Zadroik v. Iowa, South Rye Company.
That's right. Doesn't that language in Alden go to should have known about the risk, but there still has to be actual knowledge of the specific peril at issue. And then when there's actual knowledge of the specific peril at issue, then we can say the defendant should have known about the risk of harm because it was obvious. But there's no evidence that they knew about the specific risk here, which was the gate being down, right?
Focus, Your Honor, it's a great question, on the difference between peril and danger. Peril is used in element 1 and element 3. Peril is the general danger of whatever the situation is, which in this,
Peril here, how would you describe the peril?
the surge hopper working above it in the manner in which it was configured and the manner in which work was required was the peril, Your Honor.
Does the fact that the gate was missing the pins or was open come into the analysis?
That answer? Okay. So when we get to prong 2, there was actual knowledge and constructive knowledge both. There was actual knowledge that Galloway did not do his job, which was inspecting the configuration itself. He didn't do it twice. He didn't do it when the entire configuration was set up at all, and he didn't do it at the beginning of the shift, and he's required to do both. Secondly, he's required to he should be focusing on this piece of machinery because it's the most dangerous piece of machinery in this entire, at this entire site because it doesn't have a vibrator, and that's why they had to lean over and do that. And so he had actual knowledge that he did not do his job, and he did not inspect the very most dangerous thing at the very most dangerous site with the very most dangerous job.
Okay, when we're looking at element 2, would you agree that when this has been done the same way for a long time and there haven't been any other incidents, it seems like our cases require evidence about additional circumstances?
It's a great question. I actually think the lack of previous incidents mitigates in favor of our position because there are 2 ways to get to the zone of imminent danger under element 2. One is a whole series of similar occurrences, similar injuries, similar accidents that have occurred. The other one is the circumstances accrue. They coalesce in such a way that it becomes imminently dangerous, so dangerous that someone is likely to get hurt at this moment in time, which is precisely what occurred here because he didn't do his job. If he had, he should have known.
The evidence that he did the same type of inspection every time that this happened and no one had ever fallen in before?
Isn't in the record, Your Honor.
What his normal inspection was when they moved the hopper?
Of an improper inspection, which OSHA found. I mean, so it's not just an allegation. OSHA found this and is in the record, but is this specific inspection was deficient. It wasn't like any others.
Follow up then on this additional circumstances, it does seem like our cases require actual knowledge of the additional circumstances. So like in Larson, the defendant told the employee to put weight on the open auger. So it's evidence of knowledge of his own conduct. So it was the defendant actually telling the person to put extra weight on the auger. And in Swanson, the supervisor knew about the rip in the suit and told him to go ahead and work because he didn't have another one and do your best to protect yourself. Do we need, in this case, do we need some kind of evidence that Galloway had actual knowledge of the additional circumstances, or what are the additional circumstances in this case?
The additional circumstances that he did not do his inspection. He didn't do it twice. He didn't do it when it was originally set up. He didn't do it when at the beginning of the shift, and he didn't ensure that anybody else had on the most dangerous thing on this entire area. And so he had actual knowledge that none of that had occurred. This most dangerous machine had not been inspected.
Case that, or what's the best case for your position that failing to do an inspection can satisfy the additional circumstances?
I mean, I think Swanson and Larson are the most on point for us, Your Honor. And then, of course,
Are distinguishable, where in both of those cases, the defendant specifically told the employee to do something that involves a specific. It seems like it would be different. I'm having a hard time understanding how the failure to do an inspection, unless there was some evidence that, the only way that pin gets in is if the inspector makes sure that it's there.
If the court overrules Alden, because once again, we do have constructive knowledge as to prove element 2.
Didn't the employees complain about the wind, and they were told the day before to use the man lift in the back of a truck? That's pretty close to knowing, I don't know, that's pretty close to actual knowledge rather than, at least of the peril being using the man lift in the back of a truck and also, being aware that they were complaining about it being windy.
I wasn't comparing the facts necessarily as just citing Alden as authority for subjective knowledge under element 2, so.
Discussing the distinction between peril and danger, I just wanted to clarify, is it your argument that the peril is kind of the general risk of harm, here being on the machinery, and not the specific thing that caused the accident?
Yes. Obviously, there's a general risk of harm in a bomb-making factory. There's a general risk of harm when you're leaning over a rock-crushing machine. The specific circumstances, the lack of an inspection, the fact that the gate was not secured, the fact that there was no pin, and the fact that it hadn't been checked by anybody at any time in violation of OSHA were the additional circumstances that turned it from a peril into an imminent danger.
There was no pin at the time that Galloway drove by. We don't know one way or the other, right?
If the pin was in, the evidence...
Removed, right, afterwards.
There's no evidence that occurred or that has ever occurred or anybody would ever do that. So,
Was your opposing counsel right that it could have been the decedent who removed the pin?
anything I suppose is possible, Your Honor. We don't know, other than it's never happened before.
The element one is actual knowledge of the peril, correct? And your contention is there peril means danger and not the specific thing that caused the accident?
I don't think it means danger per se, and it's why this language is kind of tough to work around, because danger is in element 2. That's imminent danger. So it's not the imminent danger. The peril is the recognition that this is a perilous type of activity, a perilous situation that exists generally.
But in Walker, I think we said that peril, we talk about it as a specific thing because we're referring to it, we're talking about causation, like conscious failure to avoid the peril that caused the accident, which means the peril has to be, I think, the specific act or the thing you're talking about, and not general knowledge of that this is an inherently dangerous workplace or that there are conditions that could make it dangerous. It has to be the thing that caused the accident, doesn't it?
I believe so, Your Honor. There's actually a case, and I could find it if I could dig through here, but the peril in element 3 and the conscious failure to avoid the peril is the same word used in element 1. It's not a conscious effort to avoid the imminent danger. That is not the wording that they use. And there is a case on point that says that conscious effort to avoid the peril has to relate back to element 1, because element 1 requires actual knowledge of the general peril. And so that element 3 modifies element 1. Yes, Your Honor.
Question that I asked your co-counsel. Tell me more than just plain negligence. I think everybody admits and acknowledges there was negligence for sure, enough to go around. I'm going to even give you some examples of what I think could be gross negligence. One defendant superglued the pin so it could not be used, just to be evil. The other guy who did a drive-by inspection was playing Pac-Man, I'm assuming he's older, Pac-Man on his phone, instead of doing what he's supposed to do. That, to me, that's different. That's different than somebody, but anyways, help me understand what's going to make my jaw hit the ground on gross negligence, not just negligence, gross negligence.
One of the most dangerous industries in the country has its own OSHA.
Super dangerous. That's a given. It's dangerous.
Such, to comply with MSHA, you have to have very specific jobs at these sites, both the general safety advisor as well as the crushing coordinator, to make sure that these are safe and
Negligence, you're just saying anything that is, if there's a list from OSHA of exactly what has to be done, if you vary from that, boom, gross negligence. So anything other than exactly what's written is gross negligence? Help me understand how this it crosses the line into the world of gross negligence.
something both generally, as I've talked about, and factually in this circumstance that is this dangerous, you don't, as a safety inspector under Iowa law, is our position, you don't get to say, I'm just not doing my job and that's good enough.
I think you're telling me that because this job is so inherently dangerous, any variation, a sliver of a variation from OSHA is gross.
Slivers of variations from MSHA would not change a peril into an imminent danger, Your Honor, I don't believe.
You're saying it's not necessary for you to show, for example, that Galloway knew the gate was down or knew the pin was out, right? Did he actually saw that? That's what you're saying, correct?
His actual knowledge was that he didn't do the inspection, and his constructive knowledge was that he should have known.
His actual knowledge that it's this extremely dangerous piece of machinery that's operating under the catwalk, plus his response, plus sort of regular negligence in doing the inspection is sufficient to get to the jury. Is that what you're saying? Okay. All right.
You may be seated. Thank you.
Thank you, Your Honor. First of all, with regard to these inspections, this is the same type of inspection that Mr. Galloway did for 20 years. It's the same type of inspection that they talked about when they had their weekly safety meetings. Never a concern raised.
Opposing counsel just said that there was no evidence about what his other inspections involved. Is there evidence in the record?
That's why I encourage the clerks to do a word search for inspection. And they'll see that Mr. Galloway said he did the same type of inspection all the time. And it's not just looking for this pin or a needle in the haystack. There's other equipment out there. There are 3 other machines in operation. It reminds me of my wife looking for her keys the other day for half an hour. And I said, they're sitting right there. Well, once you know what you're looking for, it's easy to find. But to say that some inspection would have found a missing pin is what we're talking about here.
In elements 1 and 3, the peril that caused the death.
Has to be the peril.
31 witnesses, did anyone testify that Galloway knew the pins were out or that the gate was open?
In fact, they concede there's no evidence of that. If you look,
Consequences, if we held that a failure to inspect and the inspection would have discovered the peril is enough for gross negligence.
you're, I think, adopting a negligence standard and forgetting about the gross negligence standard, Your Honor.
And the grand bargain that underlines our whole workers' compensation scheme.
Complete contrast to 8520. It would
Glue and Pac-Man examples. You tell me, what would make this situation gross negligence?
that if there had been a history of accidents, if there had been complaints, if there had been employees at weekly meetings or sometimes saying, why don't we implement all of these safety precautions that in hindsight we learned about? And when they talk about those admissions, and the Court of Appeals, frankly, talked about ignored safety precautions, there were no ignored safety precautions. All of these ideas came up afterwards because this was an accident that nobody foresaw. If you look at the stockpilers, the people who were there, their reaction to Michael's accident, Jerry Malone, freak accident. No, never thought, not in my wildest dreams. Jonathan Cruz, did you even think it was possible for somebody to fall in? No. Peter Kaspers, we had never seen anybody fall in a bin before. Did you think it was possible? No.
The repeated inherently dangerous lines, how does that play in?
Do a word search, Your Honor. Inherently dangerous was taken out of context by a statement to Mr. Kulper. If you went down into this machine while it's running, would that be inherently dangerous? Absolutely. When you look at his testimony as to inherently dangerous, it's at page 177 of his testimony. When a worker is scraping on the catwalk with the rails up and secure, is that insanely dangerous? No. Is there anything unsafe about that? No. On the page before, he explains his answer about insanely dangerous and somebody being down inside that hopper. And again, that's why I encourage, if you look at the Court of Appeals decision, frankly, and the conclusions, they're not supported by the record. Look at the word hazard. Not a single employee said that this was a hazard before this accident. Afterwards, of course, they lost their friend. They wanted to know, let's not let this ever happen again. It was as unforeseeable as it was to us, it's not going to happen again. And that honest testimony should not be evidence of foresight leading to gross negligence.
The uniform instructions, against your objections, are those uniform instructions not robust enough to really explain the law in this area?
I don't think they've been updated in a number of years, and I don't think they properly encompass the words for probable. I don't think they adequately describe the elements for gross negligence. They're insufficient by themselves, and that's why our requested instructions, I think, were necessary as part of that. I see my time is almost up. I just want to conclude by saying that the district court and the Court of Appeals used the same standard in this case of gross negligence for an on-site manager and a corporate safety manager. John Kulper had no knowledge of any day-to-day work activities. He had no knowledge of what inspection was being done on that particular day. And this verdict cannot be rationalized under those circumstances unless this court decides to change the law on gross negligence and allows gross negligence to be based on general knowledge of routine working conditions in a business where there are known dangers, whether it's driving a truck, operating heavy machinery, or working where there are multiple people in multiple fields. Thank you.
State of Griffith is hereby submitted, and we'll have a brief pause while the next attorneys get ready for the case of Cooke versus Department of Health and Human Services. Here for the matter of Cooke versus Iowa Department of Health and Human Services, and arguing for appellant is Tabitha Gardner. You may begin.
May it please the court. Counsel, my name is Tabitha Gardner. I'm with the Iowa Attorney General's Office, and I represent the agency Iowa Health and Human Services in this matter. The issue before the court is one that we believe to be of first impression to the extent that it has not been subject to this court's review. It has, however, 25 years ago, been looked at by the Court of Appeals in a case that's unpublished by the name of Thiessen. Thiessen was with regard to a youth worker at the Iowa Juvenile Home, and that case is quite similar to the case before us today in that it applied the reasonable and prudent person standard under Iowa Code 232 to include similar circumstances and facts. And I believe that much of this case's contest has to do with what is considered to be relevant to the characteristics of the person and the circumstances in the employment of the reasonable and prudent person standard, utilizing under similar facts and circumstances. To that end, I'm going to make some comparisons with regard to the Thiessen case and our present case. There's actually quite a bit of parallels. We have, in this case, a state-registered child care provider. To become a state-registered provider, she had to take training and do quizzes to show that she understood safe sleep before she was registered. Safe sleep included very well-defined terms: no blankets in the bed, active supervision of a baby, and this is, a baby is defined as under the age of 1 year, an infant. That also meets up with the APA requirements that parents get and many other requirements. To that end, the reasonable and prudent person standard, as written and appropriately applied, demonstrates that HHS did in fact have substantial evidence to found this as denial of critical care, lack of proper supervision. That is the same standard we've...
I'm not following this. Why does HHS need to have a finding that Ms. Cooke was a child abuser? Why isn't it enough to just put her out of the child care business, which is, I understand, even under Judge Vaught's ruling, that's the effect. Why the need?
The Child Abuse Registry is set up to allow for record checks. It's a protective measure to ensure that people that have a history of child abuse, in this case, denial of critical care supervision, are subject to an evaluation prior to being allowed to be employed in a number of different areas with vulnerable populations, which include dependent adults and children. That can be a youth home, that can be a shelter, that can be a mental health facility, that can be as a teacher in a school. So this person not being on the registry only keeps her from being a registered home provider. It does not keep her from working in a child care center because she'd be...
What bothers, what troubles me, and you're obviously, this is the kind of case where you're going to have seven of us, each of whom thinks we're experts on the situation. This is a tragic accident of this kid being left in the pack and play with a blanket downstairs. But it sounds like something that any parent or I'm thinking myself, any grandparent could end up doing. And why are we imposing a separate standard when 232.68 applies to everybody? Why do we do a separate standard for a child care provider, especially when you're going to take that finding and use it for other contexts when the person is not a child care provider?
Well, I think you've asked a couple things, and I'm hoping to address all of those. I think that the key is...
In my old age, I'm starting to do that. Thanks.
I think the key here is that is exactly why 232.68 is set up to include under similar facts and circumstances, because there is no across the board, warm body that every person can be applied to.
Talk about similar facts and circumstances. Don't we usually mean similar facts and circumstances related to the event and not similar and not things unique to the person involved in the event?
Yes and no. I think, yes, that's true, but to the extent that there are objective things that aren't unique to that person, but are in fact common to every state-registered child care provider in Iowa, such as mandatory
Point that now you're not talking about a reasonable person, you're talking about a reasonable registered child care provider. And that's something different than reasonable person.
I think you could step back from that a bit and say a reasonable person with the training that this person had, knowing objectively exactly what that training is because she was a registered child care provider.
Further, do we really even have to talk about that? I bet I looked at thousands of child abuse assessments. Denial of critical care, failure to supervise are those are the vanilla as far as founded reports. You see those all the time. And anybody who's in the care of a child less than one, you don't have to be a registered daycare provider. You can be a mom or a dad, and we have expectations of what you should know or not know. So couldn't we look at this through the lens of even if a parent or a home, my best friend watching the kids, not registered, but I can envision a founded report for failure to supervise on these facts. I don't give a hoot what your job is. So do we really need to go, do we have to claw back that far?
Have to. In fact, in the 25 years since Thiessen, as you, Judge, I have done many, many, many cases that have been supervision cases, and they have been very similar to this in registered, non-registered parental homes all across the board. And until very recently, we have not had any issue with saying, listen, when you go to the pediatrician, when you walk out of the hospital with the baby, they tell you, here's the paper, keep them on their backs, no blankets. So yes, there has been for a very long time no challenge to that. But to the
Blanket thing, to be honest with you, of course that was horrible. I've got 9 grandkids and I've been told that you're not supposed to have bumpers in the crib and all kinds of stuff. And this is being told to me by my children who I raised with bumpers in the crib. But anyway, my point is there's some things, but the supervision factor, putting an infant in the basement long enough for the child to die and not know, I don't care about the bumpers and all that kind of stuff. That's just plain all by itself. So can't we look at it just from that? Has this case gone too far? Do we have the kind of record to support it doesn't matter what she does? Is that issue really something we have to deal with today, her career? Or can we look at it just from failure to supervise? Because the question that Justice Mansfield asked, taking away her certificate, there's a lot of other reasons to have a founded report out there. She may be a mom herself, and all of a sudden her own children, maybe there's some questionable parenting. And if I can look back as a judge and say, you have a history of this, you have a founded report from 3 years ago. So I don't care if it's the certificate or not, there's a reason to have founded reports. So can we just do a hard stop and not deal with the what was her job?
Well, and I think that's a valid point, and I think that we have actually had 2 arguments, and we've put that forth in every court that we've been in so far as to today. We believe there's substantial evidence that if you just look at a reasonable and prudent person under similar facts and circumstances, you should be able to get there and have substantial evidence.
Make that finding?
The director did, yes.
And if the ALJ rejected the finding of child abuse, then on interagency appeal, the director agreed with your legal argument and on that basis made a finding that there had been child abuse. Now, wouldn't we have to, if we don't agree with that legal point, and you know, the chief raises a point, there might be evidence to support it on even without agreeing with that legal point, we'd have to send it back to the agency, right?
Thoroughly, I think that the substantial evidence that they were looking at was any person.
I wanted to go back in time because he started talking about it from the ALJ's perspective. Before it ever gets to an ALJ, you have a CPS worker CPW worker working on it. So that's the report, even before then, that came back founded. And then an ALJ looked at it, and then the director of the department looked at it, and then the district court, and it flip-flopped every single time. It was head spinning. So the initial boots on the ground assessment was failure to supervise and denial of critical care. Is that correct? So there would have had to have been a finding of that somewhere in the record.
Was the findings in actually the child protective assessment set out that this person should have known that she'd been trained, that she was a child care provider, that she actually had a history of having a family leave because of this very issue. So there was history, there was training, there was annual training, there was all sorts of stuff.
Be clear, I understand maybe you'll prevail if it goes back to the agency, but if the final agency action being reviewed applies the incorrect legal standard, then it still has to be rebanded to the agency for the agency to make the finding under the right legal standard, or to at least apply it, and then we would review that decision if somebody wanted to appeal from it. We can't make the finding in the first instance on behalf of the director, right?
I'm not sure that I understood that question in totality.
Of the director's ruling, the conclusions of law, child abuse assessment, that's all based on the director agreeing with your view of what the law is, that the reasonable and prudent person as used in 232.6.8 and the regs includes the concept of a reasonable and prudent daycare provider for hire. And if we say that's not the right legal standard, if we agree with Judge Vaught on that, doesn't it have to go back to the agency, regardless of whether there's evidence, floating down there below that might allow the agency to then reach this same conclusion of child abuse under a different legal standard?
I think that's an argument that could be made. I'm not sure that I'm willing to stand up here and say that, yes, that's in fact what would have to happen. I do think that there's been an issue, kind of a backing up, if you will, from the administrative judges with regard to wanting to talk about under similar facts and circumstances. And I think that's why we're really here today, is that nobody's really sure what to do with that particular portion of the test. And people don't want to talk about, we have the providers council that's going to tell you that we should never look at what the person actually knows, that we shouldn't look at their history. It should all be about objective things in the room and the age of the child. But that gets outside of the scope of what you see in Thiessen, where they're looking at this man not using the MANT technique. Now,
Let me, just your point here, though. Is it a one-way ratchet in the sense that you're a reasonably prudent person and you're just me, an ordinary parent, and you're kind of at a base level, but if you've got extra training, like your person here, then they're at a higher standard? But what about somebody that's sort of has disabilities, or maybe they have, I was on the Court of Appeals, we had a lot of methamphetamine cases. Those situations, are they at a lower standard because their facts and circumstances are methamphetamine addiction?
I think that the point at which you're looking at a reasonable and prudent person, you have to consider, and I wouldn't call it a higher standard, but you have to consider the category in which the supervision issue occurred. This youth home worker in Thiessen certainly wouldn't have been applying the MANT technique if he was a child care provider, but it was applied with regard to whether he was exercising proper supervision in the context of the Iowa Home for Juveniles because of his position and because he had had that training. Similarly,
To kind of flesh this out then, maybe what you're saying is the objective facts and circumstances are that this was paid for daycare services, which would include her being a licensed daycare provider. But let's say she were doing this, it was her own child and not in a daycare setting, then maybe her training wouldn't be relevant. You would just treat her as a parent in similar circumstances because it wasn't a kind of occupational workplace setting. But this objective circumstance is a professional business that she's running out of her home. Is that kind of the gist of it?
Yeah, I think it's very close to that. I think that we've seen at the administrative level as well as the judicial review level that there's this inclination to try and compare this child care provider that's registered to a parent, to any parent. And I think if we're going to start doing that, we're mixing categories of people and we're creating categories. So to say any parent would say this, and I see my time is up. Okay. I think if you're like with New York, they look at reasonable and prudent parent, and they go to the scope of mothers. You look at the Texas courts, and they've looked at reasonable and prudent principal, reasonable and prudent parent. And they look at those within, well, would a reasonable and prudent principal do this? Would a reasonable and prudent parent do this? Thiessen, would a reasonable and prudent trained technician do this? So if we're going to start comparing apples to oranges, which is comparing a child care provider to a parent, we are using categories. We're just not comparing the same category, so we're not using the similar facts and circumstances. That's all I have.
Back. Male.
Good morning, and may it please the court, counsel. The administrative law judge and the district court judge in this matter correctly concluded that the language of the Iowa Code section and the agency rule in this matter identify a generic, reasonable person, and adding occupation and training specific knowledge to the analysis is inappropriate. In this situation, the department is seeking for the court to do what is properly left to the legislature and the agency. In this situation, we have the reasonable and prudent person test, which is discussing a generic, reasonable person. And I think where the department is trying to have this court go is to read in language to essentially make it a reasonable and prudent caregiver.
Question. I know she was a babysitter, registered or whatever. Put that aside. Baby was in the basement, unsupervised, not her child, somebody else's child. She has her own children, correct? 2 and 4-ish at the time of the incident? Okay. Were they on the main floor? Well, do you have any evidence there were any other children put in the basement?
It's common for Ms. Cooke to have children in the basement at that time.
Unsupervised?
About that.
Asking that is it seems that you can look at this from the lens of just any provider, not just a daycare provider, to have most of the activity on the main floor and have the newborn, who's the most helpless, unsupervised in the basement. Wouldn't that be looked at differently? Imagine it just as a parent. Can you see where I'm going, that it doesn't matter if you're certified or not as a daycare provider?
I think that certainly the question needs to be applied as far as we look at the facts and circumstances for the reasonable person. I think where the child is, how long the child is there, what sort of supervision is being applied as a general matter is an important consideration. It was an important consideration here, although I don't believe that that factors into the legal question that's before this court. The fact of the matter is the child was in a basement unsupervised for some period of time. I don't know that from the facts in this case we can conclude that that period of time was excessive or that it was unusual to have a child isolated in a room given the child's age.
Enough time to be excessive?
Certainly it was enough time for the child to suffocate. I don't know that from how long that takes, I think that can happen fairly quickly. That you could conclude that the time itself was something that was unreasonable from a supervision perspective. I think the problem here, obviously in retrospect and clearly, was the items that were in the pack of play with the child that caused the suffocation, and not necessarily the time that the child was isolated or not supervised.
Understand what we do with the language under the same or similar circumstances. Can't that factor in that this is a daycare center, daycare provider for pay, looking at or taking care of other people's babies?
Factors in some instances, but the way that the department is trying to couch it into the language of the statute doesn't really work here because it essentially changes the test to a subjective test. It essentially says, what is this reasonable and prudent person? who has this training or has this knowledge or has this experience do under those similar facts and circumstances.
To consider someone's knowledge and then say, would a person with that knowledge have acted this way? How does that make that subjective?
It makes it subjective because you necessarily open doors into, if it's in this situation training, maybe it's another individual's experience, maybe it's another individual's family history. You go down a slippery slope into injecting other criteria, other experiences into this person's.
When it talks about the reasonable person, it talks about it being an objective standard that the community demands, but it also talks about as circumstances, the intelligence, knowledge, and experience of the person that's involved. So what do we do with the restatement?
But I think as the language, other circumstances has been construed in the past, and I analogize to situations in Iowa law where we have profession-specific standards for attorneys, for instance, where we're talking about a reasonable attorney. There's actually language in a case for this court. I'll try to gather that here. Ledesma versus State, a reasonable attorney under the circumstances. So essentially what the department is trying to do in this situation is to say the circumstances is that this person is a caregiver. So we're looking at a reasonable caregiver under the circumstance that that person is a caregiver, and that just, it's circular.
Some of that out of necessity because the child abuse statute is one of general application. So it applies to workers and parents and all kinds of people. So you can't really identify all the specific positions that somebody who would be subject to the statute would be in. But similar facts and circumstances could at least, I would think, say in a paid daycare setting, you should take into consideration that fact that these people are trained professionals, right?
It is true that in a paid daycare setting, there may be surrounding circumstances or abilities or capabilities as far as folks who can supervise, as far as other tools at the person's disposal that would factor.
In the house, but not in the basement?
And as to why that's the case, I'm unclear at this point, but that was the case. And I think that these circumstances surrounding a particular individual, whether it's a caregiver or parent, need to be taken into consideration. And that would include whether there's video monitoring or other people who are there to help or other tools at the person's disposal to provide proper supervision. But the statute.
Go. Thank you. What work in the statute does the sort of rule of liberal construction that's built into 232, what does it do in this circumstance?
Well, I think it still can be construed in a way that enables the court to apply it liberally to protect children. The fact of the matter is, though, it is written in such a way as to be generally applicable and not something that is creating a higher standards for some individuals than others. And that, I think, is the problem that the department faces here, is that essentially the department appears to be concerned about applying this generally and concerned about, and I think you see this in the administrative law judge's findings, where he indicated that it would be hard to imagine a parent being accused of abuse under these circumstances.
I beg to differ. Leaving a newborn in the basement, unsupervised, and other kids in chaos on the main floor, you don't think a regular parent could be found to failure to supervise under those circumstances to the point where the child dies?
I think that it's certainly possible that you could conclude a parent who neglected to supervise a child for that period of time, allowing other children to, run amok, and has obviously significant harm occur to the child as having failed to supervise. I think what the administrative law judge was saying in this particular case, given how parents treat their children for naps or pack and plays or cribs, this set of circumstances, it would be hard for that administrative law judge to imagine that the state would proceed against a parent under those circumstances.
To the Chief's earlier discussion, her kids absolutely understand that you don't leave a kid with a blanket or a bumper. That wasn't how she raised her kids. That's not how I raised mine either. But when we're talking about it, it seems really hard to understand kind of where we decide what a reasonable person is. But in this case, where the daycare provider not only was provided with the information, but agreed to, I mean, safe sleep is a really big thing in the HHS regulations. So she agrees that she's going to follow these very, very specific things, and then she doesn't. Is that not a circumstance that we should consider?
Circumstance, Your Honor, I agree it's something that should be considered, but not in this analysis. I think that considering that aspect in this framework just eviscerates the objective rule and the objective approach to the reasonable person.
Getting back to this objective versus subjective, agreed to a certain set of rules, why can't you say, would a reasonable and prudent person, knowing the importance of these rules, do the same thing? How is that subjective?
I think it still then comes back to, obviously in this situation, Ms. Cooke was provided with those rules, that training, but once you inject what does this person know or what does this person's experience and training imply that they should do in this particular situation, I think you open the door to other concerns.
I mean, I really am struggling with this case a lot because, I agree that if I'm driving down the street and I get into an accident with another car, the fact that that person is a professional race car driver, that doesn't hold them to a higher standard. The fact they have better training and they're more knowledgeable and they're more capable of driving safely than I am. But if I'm out visiting the racetrack and I get in the car, as a passenger in their car, then shouldn't they be held to a higher standard if they get in an accident and I get hurt?
I think
a difference there, even if it's a general reasonable person standard.
I would agree as a matter of principle that is how we would like that to work. But the problem I see in this situation is that we are dealing with a statute and an administrative rule that has plain language and has been applied consistently by Iowa courts, and we see the same approach in other jurisdictions. One
point is the relevant fact and circumstance here that it's a business. So if you think about, to Justice Mansfield's point, if it's a car accident on the street, you're just talking about a reasonably prudent driver. If it's a car accident involving somebody who's a professional, like truck driver or a delivery driver, or if it's a forklift operator in a business, kind of non-professional negligence cases, you always take into consideration that it's a business and a person who's been trained for this position. That seems to me to be the relevant fact and circumstance. Not that she personally was trained and watched these videos and did these particular trainings. It's that she's operating a business, and it's a reasonable person operating a business, and her business happens to be daycare. Isn't that the way to think about it?
I would agree as a matter of principle, but here again we have a situation where there's a statute and an agency rule that apply this test broadly and generally without that sort of specific treatment for caregivers or, in this situation, child care professional.
A blind eye to the facts and circumstances of this case, which is it's a daycare for hire.
That this court or any court should turn a blind eye to the facts and circumstances that.
You're giving us the opportunity to even look at facts and circumstances. How can we ignore those facts and circumstances? I'm imagining a situation where I drop off my child at a daycare provider. I don't care if it's in her home or a facility. Let's say it's a facility, because for some reason I think it kind of gets warped a little bit because it's in her home. Imagine it's in a facility. And I personally, I don't think I know how to do Heimlich. I know what it looks like when other people do it. I might do a rough job of it, but I've never been certified or anything or trained. I was trained probably many years ago on CPR, but I would never hold myself out to be that person. But I tell you what, I damn well expect somebody at that daycare center, if my kid's choking on a hot dog or needs CPR, to be able to give it. And if they know it and choose not to, how is that any different than what we're seeing here? She knew the blanket thing was wrong, and she knew that being unsupervised was wrong. How can that be different? And why should we just go ahead and, as Justice Waterman said, let's give a pass?
I certainly agree that that would be my way of thinking as far as if a care provider.
Way of thinking, they said facts and circumstances. I just told you a setting where people are certified, they've been trained, they know CPR and Heimlich. Why are you not allowing us to consider that in your analysis?
Refer back to the language that the district court judge not relied on, but pointed to out of the law review, indicating that when we're talking about those facts and circumstances, we're talking about something external to the individual.
If it's as you say, couldn't the legislator have made that clear and said, we want you to look at these cases as if it was any Joe on the street, maybe even a Joe who's going to the pen, or maybe even a Joe who's already has 12 founded child abuse reports. Just look at it as any Joe. Couldn't they have said, look at it as any guy, any person? But they didn't. They said under these facts and circumstances.
But I also think that the objective person test, reasonable and prudent person test is something that is well established. May I continue? I think it's well established in law. I think when the legislature chose that language, it was intending for that reasonable and prudent person test to be applied generally without that sort of specific training or experience for the particular individual.
Isn't the fact that this is a daycare setting external to her? So imagine if she lied and didn't do the trainings. And so we're not really considering the fact that she did the trainings. It's that a person who runs a daycare should have this base level of knowledge. And that is what makes it objective, because that fact is external to her, whether she actually did the trainings or not, or whether the people who work for her did the trainings or not. Doesn't that solve the issue for you?
So the problem with that, Your Honor, is that that then creates a different reasonable and prudent person. That implies a reasonable and prudent person that has a level of knowledge, which is not something that the legislature included in.
Procedural point. Opposing counsel has indicated that we could affirm regardless. I think the district court thought we had to remand it at minimum for new fact findings. What is your view on that?
On that, I think given the record on appeal at this point, and the arguments that have been raised at this juncture, it would be inappropriate to affirm regardless.
How do you distinguish the Thiessen case involving the youth home?
Important that that case is not published. It's unclear how the department is, or what exactly the arguments that were raised in that case and how they would apply under this setting, or whether the exact arguments were raised like they are in this case.
Precedent on us, but was it wrongly decided, or why shouldn't we follow it?
The position that it was wrongly decided to the extent that it applies a different test than what I believe is called for here. Thank you.
Back to Ms. Gardner.
Opposing counsel argues that we're not being objective. I would argue that to make the reasonable and prudent person standard under similar facts and circumstances, any person, anywhere, at any time who happens to be a caregiver of a child, and then compare that generic person to this person that we have and this fact, circumstance, situation that we have, is the ultimate in subjectivity. By refusing to account for the characteristics of the reasonable and prudent person related to the circumstances present in the situation, and also to look then at the relevant facts.
Limit in subjectivity. I mean, it might be the wrong way to go, but why is that subjective?
We put ourselves in a position where we could be considering how this particular provider, with her training, her experience, her registration, all of the things that she has, that she knows, is now being compared to, let's say, a single 16-year-old mom who had her child in her home, never has seen a doctor, and we're considering and comparing those two persons. That is
Kind of is maybe troubling about your approach. What do you think of Justice McDonald's idea that maybe what matters is not the individual level of training of the individual or their age or whether they're single or, or married or whatever, but the fact that this person is doing it as a professional, as part of a job, is in a professional capacity?
I think that that goes into the factoring because it's part of the under similar facts and circumstances. I don't think that this is about category. I think this is about what a reasonable and prudent person in the same or similar facts and circumstances, in this case, a registered child care provider, would have known or should have known. And that's it.
We had a case that was a workers' comp case called TRIP, in which there was a question about whether the injury-causing incident was from an unexpected cause or unusual strain that was specific to that employee, so that, in that case, it was a 911 dispatcher, or whether it was unusual as to kind of work life generally. And because that statute didn't specify that it was as to that person, we read it broadly. Are there other instances that you can think of where we've done the opposite, where a statute uses general language like this, but we made it more specific as to that person?
I can't off the top of my head, and I think that's been part of the issue, is that there are a lot of different reasonable and prudent person standards that have been written in different contexts. We have like railroad, for example, and we've had a few cases that have been more solid in that just because it's a more highly regulated industry. I know there's one that I cited that was back from 1958 in which the person was a lookout and was partially blind, and so that affliction was considered. And similarly, this is a registered provider, so she's under requirements. So there are similar facts and circumstances that are relevant to the particular type of caregiving that's occurring. And in this case, we have, to the chief's question, we had one other infant in that basement, and it was not the child care provider's infant. All of the other children, including her own children, were upstairs. One other infant in another pack and play. Those are the only two in the unapproved basement.
Purpose of the child abuse or the child assessments, obviously, are to keep children safe in environments where they're being taken care of by someone. The situation we have right now with a certified daycare provider, imagine if it were Justice Oxley's question, maybe think of it, a 16-year-old girl. I started babysitting when I was like 14, maybe even younger. And I was put into situations where they were little heathens that I was in charge of. They used to get on the roof of the house, and I had to call my own mom to have her come down and give the mom voice because I had not yet acquired it. But anyway, my point is, sometimes 16-year-old kids without much experience get put in a situation with a bunch of little heathens running around, and something like this could have happened. I cannot help but think that the purpose of that child protective assessment, if we had those very same facts and circumstances, a 16-year-old girl put in a house with 2 infants in the basement and, I don't know, a bunch of littles running around upstairs, and then a daycare provider doing the very same thing, how can it be said that those should be treated the same?
They should be treated in context. It requires critical thinking, utilizing what a reasonable and prudent person under similar facts and circumstances, and those are the facts and circumstances. She's 16, no experience, not registered, hasn't had training. Those are facts and circumstances. To look at it with blinders on turns it into a subjective test. All we're asking is that we be allowed to continue to use the reasonable and prudent person standard under similar facts and circumstances in the same way that we have been for the last 25 years, which is to conclude that context is important. What you're doing is important. A parent with 2 children that they've known for their whole lives is not the same as a child care provider who may have known the child for 1 day and has 7 other kids there. It's not the same situation. It's not the same context. The training is not the same. To compare them is not equivalent, it's not equitable, and it's not what the test was set up to do. And I see my time is up.
Okay, thank you. The case of Cooke versus Iowa Department of Health and Human Services is hereby submitted. We are going to take like a 5-minute break for a moment. We'll let the lawyers get up here and get situated for our next case, which is State versus Jackson. Thank you, everyone. Please be seated. Our third oral argument for the morning is State versus Jackson. It looks like both parties are ready. Speaking of ready, Ms. Reddy.
May it please the court. Counsel, it is well established that error preservation requires only that an issue be raised and decided below. It does not turn on the quality nor quantity of analysis employed by the district court in making such a ruling. Here, the Court of Appeals erroneously reasoned that if a district court employs an incorrect standard in denying a motion for new trial on the weight of the evidence, then the district court will be deemed not to have actually ruled on the weight issue, meaning error is not preserved. This reasoning, however, is contrary to well-established case law that recognizes that district courts can and sometimes do employ an incorrect standard in ruling on weight of the evidence claims, and that application of the incorrect standard is itself error, which requires remand for application of the correct standard. The Court of Appeals suggests that under Meyer v. Senecalt, the defendant was required to alert the district court that it had employed the incorrect standard and seek a further ruling in order to obtain preservation of the weight claim. However, Meyer v. Senecalt only requires that an appellant seek a further ruling on unresolved issues. It does not require the litigant to re-engage the court when it has employed an incorrect standard or analysis.
Other decision or motion where if the district court judge actually makes a ruling but is wrong, that you have to file a motion to reconsider to preserve error?
Your Honor, that's exactly right. It is consistent in this context as well as other legal contexts. As long as there's a ruling, error is preserved, and we don't expect additional requests for an additional ruling in order to address deficiencies in the court's analysis. That can be done on appeal. So that limitation of not having to seek a further ruling so long as the issue is resolved, despite a deficiency in the analysis, is emphasized in Meyer v. Senecalt and also in this court's decision in LeMasters. I think LeMasters, as well as the court's earlier decision in Maxwell, are particularly helpful in establishing that the court did in fact rule on the weight claim, although it employed an incorrect standard in doing so. So in LeMasters, this court recognized that where the trial court's ruling. That's okay, I only just realized, thank you. In LeMasters, this court recognized that where the trial court's ruling references the claim at issue as being one raised in the application and presently before it, before denying the application or motion in its entirety, the district court will be deemed to have addressed that claim and error will be deemed preserved. In Maxwell, a defendant had filed a combined post-verdict motion seeking, challenging both sufficiency and weight. This court reasoned that he clearly raised the weight issue by citing to the rule provision governing weight of the evidence, and that in denying the motion, the district court must have denied the weight challenge. So this court proceeded to then address whether there was error in that determination. And in that case, the court simply went on to evaluate whether the denial was an abuse of discretion on the entirety of the record. However, in that case, there was no claim that the wrong standard was used. It was simply a claim that the motion for new trial based on weight should have been granted rather than denied.
But didn't she may have called it the wrong thing. She may have been using the wrong verbiage. But didn't the judge consider the evidence and talk about the evidence presented? Because there was only one witness. So any testimony she was talking about during that hearing had to have been that witness.
So the problem is, first we know that whether or not, there are one or multiple witnesses, independent evaluation of credibility and of weight has to be, independent evaluation of weight has to be undertaken by the district court. The problem is the court here made it clear that it was addressing substantial evidence and sufficient evidence, and is even more clear in the ruling where in the written ruling, where the court explicitly states that in the light most favorable to the state, the supposed implicit credibility determinations exist. So when the court defers to the jury determination and views the evidence in the light most favorable to the state and fails to independently evaluate credibility and weight, acting as the 13th.
In her written order, she did talk about all those things that the trooper testified to. I agree with you. I'll give it to you. She called it the wrong thing. She did. But she did the right thing.
I would respectfully disagree, Your Honor. And I point to, I think the court is looking at the second and third paragraphs of the findings in the written rulings. And the court says substantial evidence supports the verdict and makes it clear in the light most favorable to the state, the following evidence is substantial and can convince a rational jury that the defendant is guilty of operating while intoxicated, and then refers to certain testimony.
Was citing stuff from the trial information, for example, or whatever had happened at the point of just looking at the first sufficiency of the evidence ruling. But after the trial is over and both parties have rested, she gets a chance to talk about, okay, what did I actually hear? What was the evidence? And that's what she's quantifying there.
She is quantifying it as evidence that is substantial, which is a reference to sufficiency and not weight. She's
strong, and that would have gotten you out of this sticky wicket?
I think avoidance of substantial would be important, but most crucially is the fact that she explicitly views the evidence in the light most favorable to the state, which is, again, sufficiency review. It does not involve credibility determinations or weight determinations when we're looking at the evidence most favorable.
Of the evidence more than once in the fine. She followed it up with a written order, but in her transcript, she said was not supported by sufficient weight of the evidence. It's not as if she's completely off. I mean, yeah, it's confusing.
The fact that she refers to weight establishes that she addressed the weight issue, but it does not establish that she addressed it under the correct standard. We have to look at, how she applies that standard.
Question about State versus Ari.
Sure.
In that case, and I don't even know, I'm on page 706. In contrast to a motion for new trial brought under the sufficiency of the evidence standard, a motion for new trial brought under the weight of the evidence standard essentially concedes the evidence adequately supports the jury verdict. Were we wrong in saying that there's a motion for new trial where we look at sufficiency? Because sufficiency is acquittal, right? If there isn't sufficient evidence, the case ends. The motion for new trial is weight. And is there something going on with what we said in Ari that has maybe confused judges or confused people such that they think that there's multiple standards now that I think maybe has been fixed with our new criminal rule, which discusses weight directly?
I'm not sure. You know, there's certainly case law that says, you know, sufficiency is determined at or before the time of the verdict, and weight, when we're talking about the district court, is the post-verdict determination. I think that language in Ari just distinguishes the two because historically, prior to Ellis, they were considered the same thing. And Ellis, you know, overruled that prior case law and established that they're different things and distinguished them. And I think it's probably that history that maybe is, and the fact that they both involve the adequacy of the evidence as applied to different standards. I think that is probably what is confusing judges. So,
To go back and have that same hearing reconducted after the, okay.
yeah. And that is a remedy that has been afforded in multiple cases where it has been claimed that the wrong standard has been applied without any requirement or expectation that the litigant re-engage the district court and say that they employed the incorrect standard. Turning to the merits, once again, it's apparent that the district court did employ the incorrect standard. References to substantial evidence are generally references to sufficiency review, and there's no indication that there's an independent evaluation of credibility or weight by the district court, rather than simply a finding that a reasonable jury could have convicted on the evidence. And I think that's especially true or apparent from the written ruling. The court made an oral ruling and then reflected and gave us a more detailed analysis in the written ruling. And there, once again, the court employs the concept of substantial evidence, defers to the jury verdict, saying that the evidence can convince a rational jury, fails to make any independent credibility determinations, and makes clear that in reciting the testimony that supports the verdict, it is viewing the evidence in the light most favorable to the state. I would also emphasize, with regard to the state's arguments that, you know, there were no defense witnesses and there was only a single state's witness, this court, in evaluating claims that the wrong standard was used, does not undertake any sort of harmless error analysis. The court does not delve into the factual record to determine whether it would support a new trial or would not support a new trial. Moreover, however many witnesses are present, there are still questions of credibility. And here in particular, the defendant cross-examined the officer and gave a number of reasons why either the officer should not be credited or why a not guilty verdict must otherwise be returned. Moreover, it's apparent that we don't just look at evidence presented by the state as compared to evidence presented by a defendant. The lack of evidence is also meaningful in a weight analysis. So for example, in Reeves, this court affirmed the district court's grant of a new trial, including where the district court reasoned that, for example, there was no indication of motive or of a prior relationship on the record. So again, a lack of evidence can also be significant in the analysis and does not undermine the issue. With that, if there are no other questions, I will yield my remaining time.
Madam Chief Justice, and may it please the court, counsel. There are 3 distinct error preservation scenarios that I want to set out today. And these 3 scenarios, scenarios 1, scenario 2, and scenario 3, the 3 of them set out the framework that we need to have laid bare to understand what's going on here. So in each of these scenarios, I think that there are forks in the road. We get scenario 1 and 2 from the first most fundamental question in this case. It's a yes or no question. Did the district court rule on the weight of the evidence challenge? Was the weight question answered or resolved on this record? Depending on how you answer that question, we'll end up in scenarios 1, or we'll end up in scenarios 2 or 3. So if the answer to that first question is no, we're in scenario 1, and that scenario is failure to rule. The district court did not rule. There is no ruling here for a court to review. That's,
Can we take their word for it? They said they ruled?
Your Honor.
Courts.
Sure that the district court said I ruled on the weight of the evidence. The ruling is so jumbled. When you look at the transcript, the first paragraph substantively that's talking about ruling on the motion's in docket 32. The first paragraph is about a motion in arrest of judgment. The second paragraph is about a motion for new trial. The words weight appear in the discussion of that first paragraph, which is supposed to be talking about a motion in arrest of judgment.
The decision, you may disagree with the content of it, but an order is entered, the case is resolved, a notice of appeal is filed. So there's a ruling.
There's a ruling on the weight issue. I look at this transcript and I do not see a ruling on a weight issue. You cannot discern one.
Question is there a ruling on the weight issue? The relevant issue is there a ruling on the motion for new trial? And there was.
On a motion for new trial, on grounds, the defendant's motion is setting out grounds for a new trial that cannot be brought in a motion for new trial, such as sufficiency. Justice McDermott's point.
So language from LeMasters, where the trial court's ruling expressly acknowledges that an issue is before the court, and here he talks about weight, or she does, and then the ruling necessarily decides that issue, that is sufficient to preserve error. And we have the court's discussion of weight here, but it's just decided under the substantial rubric, which the court can't do.
This is why I'd like to set out the 3 scenarios. Scenario 1 is premised on the idea, it's what the Court of Appeals did. It's premised on the idea that there is not a weight ruling here, and that there needs to be a weight ruling for a Court of Appeals to review a weight of the evidence issue. Scenario 2 goes like this. There is...
I gotta tell you, this is a really bizarre theory, I think, the Court of Appeals adopted. So if you have a motion to dismiss in a civil case, and the district court judge applies the wrong standard, a summary judgment standard, you saying that's, in some metaphysical sense, not a ruling on a motion to dismiss because the wrong legal standard is applied?
Ruling, Your Honor, because defendants, this is the Meyer versus Senecott situation. The defendants, the person needs to raise and get the issue decided. It's both things.
Motion for new trial, published opinion of our court. Was there a motion to reconsider in that case when the wrong standard was applied?
Your Honor, I don't know the facts of State versus Scalise.
This is Nichter, a published opinion from this court. Reverse for applying the wrong standard. Was there a motion to reconsider in that case?
I don't know factually.
We have 5 published opinions from our court, including Ellis, which is the case that sets the standard, where there's no motion to reconsider filed, and we remand it for a ruling applying the right standard. So let's set aside the debate about scenario 1, 2, and 3. On the 5 published opinions we have on this issue, we've never required a motion to reconsider. So why is the Court of Appeals right?
when the scenarios are actually quite helpful, and I do want to set them out. Scenario 1 is the no ruling path. That's what the Court of Appeals did. The premise there is if you don't secure a ruling on an issue to preserve it, it needs to be raised and decided by the district court. If the district court didn't decide it, you do not have a preserved ruling to be reviewed. If the district court didn't rule, you had an obligation to file a Rule 1.904 motion or some sort of equivalent motion to preserve your error. That's scenario 1. I understand that that scenario does not appeal to you, Justice McDonald, so I'd like to talk about scenario 2. And in scenario 2, what's happening there,
Me, it's that there's no case that supports it. We have 5 published opinions that explicitly remand a case on a preserved error, on a ruling for a motion for new trial that applies the wrong standard, and we said error is preserved and we send it back. So it's not that I disagree with your framework. I just need a published case from this court that adopts it, or at least is not contrary to what we've done since 2003.
the fault line between the Court of Appeals, what it did, and what you're saying is a fundamental disagreement about the nature of the mistake in this record. I think on the one hand, the Court of Appeals is looking at this situation pretend just a real life example. Last night, I was talking to my wife about making some dough, and I said, let's mix the dough by hand. And she thought that I meant to grab a wooden spoon and to stir it, as opposed to grabbing it with your actual hands and kneading it. She was thinking I was saying mix it by hand using a spoon as opposed to using the KitchenAid, but I meant by actual hand. That sort of mistake, you can't tell from the words mix it by hand what I actually meant. It really could be either thing. I was not sufficiently clear to know whether that meant use a spoon or use your actual hands. I think the Court of Appeals sees this record in that way, and that is a reasonable way to read this transcript, because the ruling is so garbled and the underlying motion as well that the defendant filed is also very full of mistakes, and it's confusing. I think you're looking at
But, this argument about the framework and whether the framework appeals to me, 6 of us are motion judges, and she doesn't get to join that. She has other things to do that I'm glad I don't have to do. But 6 of us are motion, and we commonly see, as motion judges, in a situation like this where it's just clear that maybe the simplest way for the state to handle this would be to agree that file a motion in reverse and send the thing back down so that the district court can apply the correct standard on the motion for new trial on the grounds that the verdict is against the weight of the evidence. And wouldn't that be a more practical approach to deal with this problem than having this kind of debate? Because it seems to me even maybe the state is not sure about what is really going on. You sort of suggest that, and then your brief on the one hand argues that evidence, the issue is not preserved, and on the other hand says, well, not only is the issue preserved, but the district court applied the correct standard. In that case, why not just send it back and let the district court clean up what it did?
Going on for 25 years, and the standards are markedly different. It's pretty obvious which one is which, and this problem is still continuing. I think this problem arises in part because defendants' motions are not very clear. You can look at the face of the defendant's motion here and find no less than 5 stark mistakes.
Well, yeah, but counsel, you would agree it says weight of the evidence. The motion does. I mean, the motion lays it out pretty clearly.
That's in number 5. So
here isn't that the defendant, I don't think that the defendant didn't properly raise it. It's whether the court ruled on it.
the evidence. I'm not saying that the defendant failed to raise weight of the evidence. What I'm saying is that we have a persistent problem with district courts getting this standard right. You know that.
And I'm thinking, let's move beyond the preservation of error, and then what do we do? And when you say it's been a persistent problem, I've been that new judge before, and I very well could have said the wrong magic words at the close of the state's case versus the close of the trial, motion for new trial. They are tricky, and that's why I had something called a bench book. And where do you suggest we go? What's your argument, assuming preservation of error is not an issue, that we're going to say it was preserved? Then where do we go?
So this is scenario 2. If the court believes the district court ruled but used the wrong standard, there's one final fork in the road between scenarios 2 and 3, and that's, was Jackson required to alert the district court to preserve error?
No.
The answer is no. We are now in scenario, we're in scenario 2. So in that's assuming the error was preserved here. The issue then is the merits, and that's the core of my brief. That's an alternative theory to preservation. And if we're willing to go to this transcript and we're willing to ignore the problems with a motion and arrest of being judgment being asked for when there's no basis to seek a motion for arrest of judgment, and we're willing to ignore that paragraph 5 of the motion in docket 32 contains a request to grant a new trial on an evidentiary basis, and if we're also willing to overlook the fact that sufficiency of the evidence is being used as a basis to ask for a new trial and not to vacate the conviction, I think if you're going to look at the transcript, set all of those things aside, what you have to do is look at those 2 paragraphs as a whole in connection with the written ruling and say, can we cobble together a ruling on the weight of the evidence here? If you're going to look at everything and you're going to overlook misuse of the word substantial and sufficient, you have 2 references to the weight of the evidence in the first substantive paragraph of the transcript from the hearing. You have a written ruling, as the Chief Justice pointed out, that uses the word sufficient evidence, substantial evidence, and talks about taking the evidence in the light most favorable to the state. But then you have credibility, you have evidence statements where the district court's clearly weighing the evidence and talking about how probative it is or how convincing it is. The transcript uses the word overwhelming. That word overwhelming in a one-witness trial has to mean that the witness was credible. It cannot possibly mean anything other than that the witness was credible.
Years, and it's a problem. And I've been a judge now almost 20 years, so obviously I've been part of the problem. But if that's a problem that needs to be resolved, and if we get beyond the preservation of error, wouldn't we be more likely to resolve the problem by sending it back in an opinion that says, do it right, instead of saying, you got close enough, endorsed? Isn't that going to just proliferate the 25-year problem?
Clear to me that the first thing will solve this 25-year problem any better than the second one would. What I think needs to happen is, if you're asking me, is this court should require defendants to chime in when the district court is starting to get this standard wrong, especially in instances like this one, where the defendant has invited the error by filing a motion that contains so many substantive mistakes about motions in arrest of judgment, motions for new trial, and sufficiency of the evidence. If you don't want to do that, I think this problem will persist, whether or not you remand here and say do over, or whether you say this was close enough.
Do that, I agree. That's a bigger target, though, than judges. I know if I got a remand back and told me, hey, you did this instead of that, I mark my words. I'll never do that again. And I am the judge of many, many, many cases. And as a judge, I could say, okay, defendant counsel so-and-so, you called this, a motion for new trial, but you're asking me to do sufficiency of the evidence, whatever. Isn't it also the job of the court to notice, wait a minute, this motion is going to be denied because you're doing all the wrong stuff? Couldn't we accomplish the same thing that way?
There's responsibility on both parties for sure. I think the locus of the wrong here and why this problem is so persistent, respectfully, is because the defense bar consistently files motions seeking for sufficiency review in a motion for new trial. Certainly since RA, that's been the case.
Catching it?
But if you're asking between the two, the locus of the wrong, I think, is more on the persistently misfiled and incorrect motions.
That the new rule, the new criminal rule, which specifies weight for the new trial motions, might help that?
I absolutely would urge this court to make that crystal clear in this opinion, really take the opportunity to explain that sufficiency challenges do not belong in a motion for new trial. That's why I'm advocating that this court consider putting the locus of the wrong here more on the defendant than on the court. And either way, this opinion should send that crystal clear message so that the motions stop. And then the district courts aren't going to confuse the two standards as, I mean, it still will happen and could happen, of course, but it's much less likely that a district court's going to bungle the two standards when those two requests are not intertwined in the same motion.
Lawyer and judge bungling this up, right?
Yes, and that's true. Again, I think the locus of the wrong, the root of this problem, if you want to fix the problem, I think it's to request more, demand more of criminal defendants who are seeking to preserve error on this issue. When they stop making this mistake in the motion, the mistakes at the district court level will drop. It won't be completely eliminated. But there also is an element of reminding the district courts yet again, whether it's in this opinion or in training, or I don't know exactly how, to stop confusing the Ellis standard with the sufficiency standard.
Who was our district court judge here?
I have the name of the judge. I believe it's, I could.
Beatty.
It's on the bottom of docket 35, Your Honor. Without any more questions, the state would ask this court to affirm.
Just briefly turning to the state's argument about whether the issue was adequately raised in the motion, I think is one of their arguments. And I would just note, as has been discussed, it is explicitly laid out as the verdict being contrary to the weight of the evidence in a separate paragraph in the motion. And it was argued at the hearing as well that the weight of the verdict is against the weight of the evidence. In Tibbs, the U.S. Supreme Court recognized that courts are expected to and routinely do differentiate between sufficiency and weight claims. And I would contrast this case, where weight is specifically referenced in the motion, with this court's decision in State v. Thompson. In that case, the court determined that the weight issue, that's a 2013 decision. I don't believe it's cited by the parties, but it's in Rethwich and discussed. So in that case, the court determined that the defendant had not adequately raised a weight challenge, in that they did not reference, the motion only argued that it was contrary to the evidence, focused only on evidentiary issues, did not reference weight, did not reference the rule governing weight, and did not reference Ellis. So there was nothing there in the court's opinion to trigger raising the weight challenge. That's in contrast with the present case, where the motion references and argues the verdict is contrary to the weight. With regard to the merits, the state points to the reference in the oral ruling to overwhelming evidence. I would note that that statement is made specifically not with regard to any sort of evaluation of the evidence, but with regard to whether the denial of the evidentiary issue, the suppression of an exhibit, was harmless. And so that really only establishes the court's determination that, there was plenty of other evidence from which the jury could find guilt, even if that exhibit was excluded. It does not establish any sort of independent evaluation of credibility, any sort of independent weighing without deferring to the jury. And once again, I think it's made particularly clear in the written ruling that the incorrect standard was applied.
The incorrect standard was alluded to in your client's motion?
I don't think so, Your Honor. It's true defendant raised both sufficiency and weight challenges. This court has found error preserved or granted relief.
Reservation. I'm just talking about the motion itself. Mr. Banta was talking a lot about this prolific problem for 25 years, and it may start oftentimes with a motion, and it may be continued by a judge's ruling. So in this case in particular, weren't the wrong terms used with the wrong motion?
I think so. The defendant did not argue weight should have been evaluated under sufficiency. The motion does raise sufficiency or directed verdict as well as weight of the evidence. The weight of the evidence is listed under a separate paragraph, and like I said, courts are expected to understand the difference in those standards. And in the published Court of Appeals decision in Root, that involved this kind of mixed motion where both sufficiency and weight is raised, and the court remanded, concluding that it was raised, but the court applied the wrong standard in ruling on weight.
Grounds for granting a new trial exist for the following reasons. So new trial. Which standard do you think should have been used? What's the magic language for new trial?
The evidence.
Counts was supported by insufficient evidence. So didn't they say it wrong too?
I think, if anything, maybe, to the extent this court concludes that sufficiency claims cannot be raised in post-verdict motions, that's a problem with the sufficiency claim. It doesn't mean the weight claim, which is separately raised and addressed by the court, is improper in some way at that point.
The motion for directed verdict language is, hold on here. In your client's motion for directed verdict, it talks about evidence. They should have or shouldn't have let in Exhibit 102. So my point is, as far as the preservation of error, the court, it ruled on something. But I just want to say there's a lot of blame going around, wouldn't you say?
I think certainly this court can reason that the defense motion could have been clearer, but that is a different standard than error preservation.
Interesting that the defense's entire argument is how bungled up the court made this and oblivious to what was put on a platter before the court. But that's maybe more of a statement than a question.
With that, I would request remand for application of the correct standard. Thank you.
State versus Jackson is hereby submitted, and the court is adjourned for the morning. I have to give myself a demerit. Thank you.